something up at IKEA that's still in a box and come home and let's say ask my teenage sons to help me unload the car, I would say, I bought a couch at IKEA. I need your help. And I think we would refer to it as a couch, depending on the context, even though it still needs to be put together. I've bought furniture from furniture stores and online that like futon beds or things like that really required just tightening, a very little work putting it together. You really just needed a screwdriver and put the two big pieces that were mostly complete together. And I have bought other things that I had to give up and just couldn't do, right? Like I spent hours trying to assemble something and failed. And that was actually, that whole conversation or those experiences were talked about at length in the oral arguments. You brought up the omelet analogy. Justice Alito said, if I set out eggs and chopped ham and peppers on my counter,
pepper and onions, is that a Western omelet?
And the Solicitor General said no, because you could actually do other things with those ingredients, and maybe are just as likely to. And then Justice Barrett jumped in and said,
I just want to follow up on Justice Alito's question about the omelet.
I think maybe a HelloFresh kit would be a better analogy, where you get a box and it's clearly marketed and sold as just mix these ingredients together in the order we describe. We have everything you need for the meal and you'll have a complete meal. And that's, I think, going to be part of the question in this case, is whether this is more like just looking in your fridge and seeing what you have to put together for a possible dinner versus getting a HelloFresh kit that is marketed and sold and purchased as a complete meal in a box. And it wouldn't be that weird for people to say, oh, dinner was just left on the front porch, even though they still have to put the ingredients together and heat it up. I do want to say that there were, in the online discussions about this case beforehand, there were some issues that didn't get a lot of attention from the justices. I think that they didn't take it that seriously. So, for example, the question of whether this rule affects people who, a hobbyist who is buying each part individually, like a gunsmith, and assembles a gun for their own use at home. The regulation itself is very clear and says over and over again that it doesn't apply to that situation. This applies to introducing a gun into commerce. The other thing I want to say that Justice Roberts and some of the conservative justices were concerned about is that these kits are being used to circumvent the entire sort of regime of federal law about firearm sales. And all that's really required of the parts kits company is to put a serial number on it and keep records of that for the government, so that if it's put together and the police recover it from a crime scene, which is happening a lot now, they can have some hope of tracing it. But those serial numbers are also sort of serve the purpose like of your social security number for the taxes that apply to guns, for background checks when they apply, and other things like that. And this is basically something that, if the challengers are correct, it essentially thwarts the clear intention of Congress in other regards. And I think that argument got a lot of traction.
Clark, on the broader question of how significant ghost guns are in the market, how significant are they? How big a deal would it be if the court requires them to carry serial numbers? And do you think that they should be covered by the Gun Control Act or not?
Yeah, let me first, if I may, really quickly come back to this issue of the couch versus the omelet. I want to say one thing. it is true that Elizabeth Preligars is among the most gifted advocates of her generation. She's apparently among the most gifted gunsmiths of her generation as well, because she claimed to be able to take a kit and assemble a gun in something like 20 minutes. There's an amicus brief from a former high-ranking ATF official who says that it is almost impossible for a sort of a non-expert to assemble one of these kits. You'll almost always get it wrong. It takes a minimum of somewhere like 5 to 7 hours, even if you have the necessary tools, which you're normally not going to have in your house. So there's a really interesting, I think, discrepancy in terms of credibility between this person, the former ATF official, and the Solicitor General. And I think it shows the limits of analogies, right? Because it's not the case that every gun kit is the same. Some of them would be like a couch. You get the box, you pull it out, you open a valve, and the couch inflates itself. And there's literally nothing else that you need to do. Fair enough. That's a functional couch. The other end of the spectrum, you could have a couch, quote unquote, that comes in a box, and you have to do a lot of carpentry. You have to change some shapes. You have to machine tool some bolts to fit into the holes that you made, et cetera, et cetera. And gun kits come in all those different variations. So it could be that we'll have some discrepancies. If the court gets that far, there may be some kits that are like, yeah, this is just turnkey. So that's definitely a receiver, even though it's not quite there yet. And others, they'll say, hey, that's a lot closer to a hunk of metal. No ordinary person's going to be able to turn this into a receiver. So could be that we get a remand to the lower courts for more fact-finding. But as far as this, the significance, it's always interesting when people use pejoratives right out of the gate. So, for example, in the Hardwick case involving gay sex, we were told that the act in question was sodomy. But then when we get to Lawrence, it's not sodomy anymore, it's intimacy. And similarly here, one person's ghost gun is another person's privately made firearm, or PMF. And these are things that people have been making since the time of the founding in their own homes. There's nothing sinister about somebody making a gun at home. There never has been. There's been very little regulation of it, if any, at either the state or the federal level until very recently in our nation's history. And the law is that you can make a gun at home. You don't have to put a serial number on it, as long as you're not making it for the purpose of selling it to somebody else. So I think that this law, or this new rule, is likely to affect the conduct of a relatively small group of people, but one that is going to be able to make a very strong case that what they do in terms of taking parts and turning them into functioning firearms is something that people have been doing in this country for hundreds of years. And that even, in the founding era, when the British made it difficult for the colonists to get firearms, some people made their own firearms so that they could resist British tyranny. And I think the court has made very clear that it's sensitive to that kind of history. So in terms of how big a deal this is going to be, in the event the court upholds the ATF rule, which I agree with Drew that it's likely to do, I think we will not have seen the last of this issue, because I do think that there are possible constitutional challenges, perhaps more of an as-applied than a facial nature. And I don't think that every gun kit that people find themselves working with are going to fit comfortably within the ambit of this new ATF rule, even if the rule itself is upheld facially.
Drew, what are your thoughts about the future of gun control regulations if the court does uphold this one? Do you see future constitutional challenges? And how does this fit into the important debate on the court about administrative law and how deferential the justices should be to agency interpretation of congressional statutes?
So I'm going to start by saying Mr. Neely and I agree that the court seems likely that a majority of members of the court will uphold this particular regulation, and I agree with him that not all gun kits are the same. And the Solicitor General conceded that at oral argument, and basically left the door open for someone to bring some kind of as-applied challenge and say, look, my kit was very difficult to assemble. You really had to have special equipment and machinery and so forth. And that would be something that a defense someone could raise to a prosecution. And remember that ATF would also probably, she said, not bring such a case, had no plans of bringing cases for those. But some things have changed since the founding era. I do want to say, in the founding era, General Washington came up with a system of embossing numbers on all the guns that were brought to the Continental Army or that they collected from British soldiers on the battlefield and so forth, because people were walking off with the guns when their tour of duty was over. So we also have a long, long tradition of putting serial numbers on guns so that they can be traced in cases of theft or misuse and so forth. And the difference between an individual hobbyist making their own gun at home in their garage and these cases is these are being mass marketed online. And the technology that changed since ATF last issued a rule about this, about what counted in the early, believe in the early 70s, is that not only are they able to market things more easily on the internet, but there are jigs or templates that make it much easier for a novice to put them together. Now, in terms of the future, obviously that we have there's a lot of, I would call it chaos in the lower courts about the status of how to apply the Second Amendment after Bruen and Rahimi. And it's very hard to predict what will happen. This particular case was not, I want to reiterate, that was not a Second Amendment case. It's not going to be decided on Second Amendment grounds or the history and tradition text or things like that. There are other cases working through the pipeline that are challenging other aspects of the Gun Control Act and that could end up bringing up the serial number rule itself, not just whether it applies to these guns. But based on the oral arguments, I didn't really see a majority of justices saying, we don't think the government has any business requiring serial numbers, period, on guns. So I don't think that that's going to get a lot of traction. How much difference will this make? That actually was a big argument, big part of the oral arguments. That, based on statistics, the police every year are recovering around the country are recovering more of these what they call ghost guns from crime scenes, so that it's now in the thousands every year. If you want to commit a crime and get away with it, this is the gun for you, right? It's an untraceable gun. And so the argument is that these are disproportionately appealing to people that want to do something that they don't want to get caught for with their firearm. And because otherwise you could just go buy a regular firearm or maybe buy a kit where the frame or receiver indeed has a serial number on it, or make your own at home and not have it go into the stream of commerce at all. So this is becoming a significant crime issue. I do think that the companies that have been making these a lot of them are going to be shuttered or go out of business if the court upholds the rule.
Well, let us now turn to the constitutional question and the future of gun control regulations post Rahimi, the Rahimi case that the court recently decided. Clark, you wrote the section on Rahimi in the Cato Institute's comic book on the Supreme Court term, which is a unique and entertaining pamphlet. And you sum up very clearly in comic book form how the justices have disagreed post-Rahimi about the role of text and history in interpreting the Second Amendment. Sum up that debate and what you think the future of ghost guns and other gun control regulations is post-Rahimi.
Well, that's a lot to bite off, but the gist of it is that usually when the court tries to adjudicate a constitutional case where someone's asserting a right to do something and the government's asserting a power to regulate that thing, they'll do a kind of a balancing where they'll say, look, the government has to have either a very good explanation for regulating this conduct or a pretty good explanation or even just a conceivably good explanation. And there needs to be some fit, maybe a very tight fit, maybe a very loose fit between the government's stated interest and the regulation that they've issued. In Bruen, what the court did was jettison that framework that, again, applies in most other constitutional settings in favor of something that's come to be called text, history, and tradition, or historical tradition, where they look back in time, and they don't even really tell us exactly when or how far back to look, but we look back to some point in the nation's history to see if there was a similar regulatory scheme And if so, then the law that's being challenged today is probably okay. And if there's not, then it's probably not okay. Many scholars, and I would say myself included, have identified serious challenges and problems with this new historical tradition approach. I